In aviation, fear doesn't always come from storms or mechanical failure. Sometimes it comes from a courtroom. For decades, plane manufacturers believed that if they followed regulations, passed certification, and logged enough flight hours, they were safe. Not just in the sky, but legally. That belief shattered after one lawsuit. A case so disruptive, so financially dangerous, that it forced aircraft designers, executives, and insurers to rethink everything they thought they knew about responsibility in the air. This isn't the story of a crash alone. It's the story of what happened after, when grieving families walked into courtrooms and asked a question that shook the industry. Who is really at fault when a plane fails? The case began the way many aviation disasters do. A routine flight, experienced crew, a jet that had already proven itself reliable. No warning signs dramatic enough to ground the aircraft. And then, mid-flight, something went catastrophically wrong. What investigators discovered was uncomfortable. The failure wasn't caused by a bird strike, not by weather, not even by poor maintenance. It traced back to a design decision, one that had been debated quietly inside engineering teams, approved through certification, and accepted as within limits. But within limits didn't matter to the families who lost everything that day. When the lawsuit was filed, manufacturers expected the usual outcome. Aviation cases historically were difficult for plaintiffs. Juries tended to trust big aerospace companies. Regulators had signed off on the design. Pilots were trained. Airlines operated the aircraft. Responsibility was spread thin. This time it was. Plaintiffs' attorneys focused on something radical for the era: internal documents, engineering memos, risk assessments, emails that showed engineers had anticipated the failure, calculated it, debated it, and ultimately accepted it as an acceptable risk. That detail changed everything. In court, the narrative wasn't about an unforeseeable tragedy. It was about a known vulnerability that made it into the final aircraft anyway. The argument was simple and devastating. If a manufacturer knows a design can fail in a specific way, and that failure can kill people, how much risk is acceptable? Jurors listened. Executives testified. Engineers were called to the stand, forced to explain technical compromises in plain language. Charts showing probabilities and failure rates were suddenly translated into something far more human: lives. The lawsuit dragged on, and with every week, anxiety spread across the aviation world. Not just one company, all of them. Because if this case succeeded, it would set a precedent, a terrifying one. It meant manufacturers could be held liable years, even decades, after an aircraft entered service. It meant certification wasn't a shield. It meant design trade-offs, once buried in technical language, could become center stage in front of a jury. Insurance companies noticed first. Premiums skyrocketed. Some insurers refused to cover certain aircraft models altogether. Others demanded design changes before renewing policies. Suddenly, it wasn't just about safety. It was about survivability as a business. Inside boardrooms, the mood shifted. Engineers who once lost arguments over cost or weight were suddenly being listened to. Redundancy was no longer a luxury. Fail-safe design became non-negotiable. Not because of regulation, but because of fear. Fear of another courtroom. The case eventually ended in a settlement, but by then, the damage, or transformation, was already done. Manufacturers quietly redesigned systems. Manuals were rewritten. Certification standards tightened. Legal teams gained more influence than ever before in aircraft development. And yet, the public barely noticed. Passengers kept flying. Airlines kept ordering jets. The lawsuit faded from headlines, but inside the industry it became a warning story passed down like folklore. Don't let it become another that case. What made this lawsuit truly terrifying wasn't the money, though the numbers were staggering. It was the shift in power. For the first time, manufacturers understood that public trust and legal accountability were inseparable. That safety wasn't just an engineering goal. It was a legal obligation with consequences that could echo for generations. And this case wouldn't be the last. In the years that followed, every major aviation lawsuit carried its shadow. Different aircraft, different failures, same question. When something goes wrong at 35,000 feet, who answers for it on the ground? By the time the industry fully understood what that lawsuit meant, the rules of aviation had already changed. Manufacturers stopped asking only can we build it, and started asking can we defend it. Every bolt, every line of software code, every design shortcut now carried a second weight: the question of how it would sound in front of 12 ordinary people in a jury box. Because here's the uncomfortable truth the lawsuit exposed: juries don't think like engineers. They don't speak in failure rates or probability curves. They think in stories, in warnings ignored, in emails that say, "This might be an issue," followed by decisions to move forward anyway, in lives that can't be brought back once a calculation proves wrong. After the case, design meetings changed tone. Engineers who once argued against certain choices weren't dismissed as overly cautious anymore. They were documented, their objections logged, sometimes acted on, not always because of safety alone, but because ignoring them could become catastrophic in court. Legal teams began sitting in on early-stage aircraft development. Not at the end, not after certification, at the beginning. Their job wasn't to design wings or engines, but to spot vulnerabilities that could later be framed as negligence. That shift rippled outward. Regulators quietly adjusted expectations. Certification became more demanding, not just in testing, but in documentation. Proving why a decision was made became as important as proving how it worked. Airlines began asking harder questions before signing purchase contracts. Some even walked away from aircraft that carried legal uncertainty, not technical flaws. And then came the next wave of lawsuits. Different planes, different manufacturers, different decades, but the same strategy. Lawyers went straight for internal discussions. They searched for moments where safety, cost, and schedule collided, and where safety didn't clearly win. Each case reinforced the lesson: compliance is not immunity. Manufacturers started settling more often, not because they believed they were wrong every time, but because trials were unpredictable. One emotional testimony could undo years of technical defense. One internal memo could outweigh thousands of safe flights. To outsiders, it might look like the industry was being punished, but inside aviation, many saw it differently. They saw it as a correction. For years, the system assumed that if something met regulations, it was safe enough. The courtroom forced a harder standard, one rooted in foresight, not hindsight. It demanded that companies think not only about what is allowed, but about what is right when lives depend on it. Of course, there was resistance. Executives warned that endless liability would stifle innovation. That fear of lawsuits could slow progress, drive up costs, and make aircraft unaffordable. And to some extent, they were right. Planes became more expensive to design. Development timelines stretched. Layers of review piled up, but something else happened too. Accident rates continued to fall. Redundant systems became the norm. Software oversight improved. Human factors, how pilots actually interact with machines, moved from the margins to the center of design philosophy. Lessons once learned only through tragedy were now anticipated, all because one lawsuit broke the illusion that manufacturers were untouchable. Today, when you board a flight in the US, the UK, Australia, or anywhere else, you're stepping into an aircraft shaped not just by aerodynamics and physics, but by legal fear, by past verdicts, by cases most passengers have never heard of. The irony is hard to miss. The courtroom, a place far removed from the sky, may have done as much to improve aviation safety as any wind tunnel or simulator. But the question remains unresolved. How much responsibility should manufacturers carry? Where does accountability end? At the drawing board, the factory floor, the cockpit? And at what point does fear of litigation start holding progress back instead of protecting lives? Those questions are still being argued today, behind closed doors and under oath. What's clear is this: after that lawsuit, aviation manufacturers stopped believing they could hide behind regulations. They learned that trust is fragile, and once broken, it doesn't come back easily. The sky may look calm from the cabin window, but the forces shaping aviation's future are just as powerful on the ground, inside courtrooms, contracts, and decisions that never make the news. And the next case that truly terrifies plane manufacturers may already be building. If you found this story insightful and want more deep dives into the hidden forces shaping aviation and technology, make sure to support the channel, subscribe, share your thoughts, and stay with us for the next story that history almost forgot.